Discovery should be
Discovery.
provided.
Don't play word games with me.
I'm not playing.
Mr. Allen, not play word games with me. You're playing with the wrong judge.
I'm not trying.
I'm giving you your warning.
I would like to first have a jurisdiction hearing.
So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong.
All right, folks, buckle up, because this courtroom just turned into a circus. We've got yet another sovereign citizen walking in, convinced he can outsmart the judge with word games and YouTube legal theories. And let me just tell you, it goes downhill fast. The moment this hearing begins, the defendant starts talking about how he has no contract with the public defender. Yeah, you heard that right. No contract. As if...
Hello, Tariq Samar Tarikade here.
Already, Judge. Courtroom Feaster Assistant Public Defender on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office to represent me.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
Is this going to be a Bellinger's thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had enough counsel that he's going to have, I believe, on his file. And I wish him good luck if that's the case, but I don't see another attorney here. So I don't know what's going on, Your Honor.
No,
Mr. Day?
I'm defending myself. I told him that I would notify the court that I relieved him of any implied obligations to this case.
So you're going to represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now.
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no way I can.
In a vehicle with a hat on, no mask. Oh.
I am inside my vehicle right now.
What'd you say?
I said yes, because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you go to the hospital regarding the COVID diagnosis?
Excuse me?
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're going to do. Then I'm going to say, okay, you've got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask if you're going to represent yourself.
I can't make that. Is there a later date?
Oh, yeah, you can. 3 o'clock.
3:30, I can make that.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then
okay. And at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
See you
didn't
at 3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line.
Criminal defense works like signing up for cable TV. The judge tries to keep things steady, but already you can feel the tension rising. Now, when the judge tells him he needs to show up in person, this guy suddenly claims he has COVID. Sounds serious, right? But here's the problem. He's sitting in his car, no mask, hat on, looking perfectly fine. When asked if he saw a doctor, he actually says going to the hospital is against his religion. At this point, even the judge is done playing. Along, he sets a firm time. 3 p.m., be here, or I'm issuing a bench warrant. And here's where the games begin.
You indicated that you wish to represent yourself on this matter?
Yes.
All right. You understand at your arraignment, you were given the charges that were have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeing and eluding.
Fleeing and eluding, third degree.
Third degree, correct. And if anything else was tallied onto that, then I was not told.
I have one charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
First, I wanted like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of a personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party, Wall Street Towing, and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department. Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser. With the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
The defendant tries to twist it. He says, well, I can't make 3 wow, but I'll come at 3:30. The judge doesn't buy it for a second, tells him to show up at 3 wow sharp, and warns him that if he's late, that warrant is coming. But guess what? He shows up at 3 wows anyway, proving he knew the judge had authority over him the whole time. Now here's the kicker. When he finally appears, the judge lays out the charges. Fleeing and eluding, a felony that could land him 5 years behind bars, plus fines and a suspended license. Instead of responding like a normal person, this guy goes full sovereign citizen mode. He starts rambling.
Finish.
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust. And I'll be able to supply you all with the adequate assurance, certificate of security to settle and offset the charges.
Okay. Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing,
This is a probable cause hearing.
so I don't understand what you're saying.
I know you don't understand.
They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was
You weren't able to do what?
provide my exhibits
To whom?
to the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point. So they will be here, if not by the end of the day in the drop-off box, and you'll have them all tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not this time.
All right. So how would you like to proceed next on this?
Entering a plea of demurrer.
Okay, you've already done.
About trust property, colorful laws, and fictitious entities. According to him, the state of Michigan doesn't even exist, and apparently neither does the court's jurisdiction. The judge listens for a moment, then cuts him off. Motions denied. End of story. But of course, this guy isn't finished. He insists that without an injured party, there's no crime. He claims his car is part of some mystical trust, and even tries to appoint the judge and clerk as trustees. Folks, I wish I was making this up. It's like he pulled legal jargon out of a cereal box and thought it would hold up in court. And the judge? Absolutely stone cold. He tells him straight, nothing you're saying makes sense.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer. There was
You stood mute, you stood demure. You don't even know what that means. You're just using words and have no concept
No.
as to what they mean.
demurrer and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not,
No need to-
they are not,
I'm not here.
they are virtually the same thing. So where do you wish to proceed now?
As I stated, my
Do
motion,
you wish this set for preliminary examination? Your motions have been
I
denied.
wish for the prosecution to provide the evidence that any of this needs.
You
to-
don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about
Do
it.
you wish to have
Discovery should be
discovery?
provided.
Don't play word games with me.
I'm not playing.
Mr. Allen,
Discovery,
not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
Yes,
Sir, did you wish to then have another PCC, or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing,
What kind of jurisdiction here?
personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
This is a probable cause hearing, not your fantasy courtroom. The tension is thick, the defendant's smirking, the judge is snapping back, and it feels like any second the roof is about to blow off. So now the courtroom's boiling. The judge asks him a simple question. Do you want discovery? That's standard. It means, do you want to see the evidence the state has against you? But instead of just answering, this guy starts smirking, dodging, playing word games. And the judge? Oh, he's not having it. He leans in and says flat out, don't play word games with me. You're playing with the wrong judge. That was the moment right there. The warning shot. Any smart person would back down, but not our sovereign citizen. He doubles down asking for a jurisdiction hearing.
Court, as well as the state, lacks personal jurisdiction. I'm simply here under threatened arrest or coercion of you, saying that you would hope put out a bench warrant for my arrest. The subject matter, in regards to the name as well as the vessel that was used, is again under. It was conveyed and is held and protected within the trust. And according to Article 1, Section 10, Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly and the trust is properly functioning at this time. So with that,
All right, so here's what we'll do, because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong. Because I have subject matter jurisdiction over you and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the State of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
awesome. So that would be the next step, and I can get those in today.
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
Yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine, and then I will file the proper documents for the jurisdictional hearing. Gotcha.
So I'll adjourn the probable cause conference in this case. April 25th, 2024 at 3 p.m.
Is it possible to get another week for
person
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I mean, I was on the call. I've heard you give multiple counsels extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable.
setting the date
So
of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PC, to a preliminary examination.
Just on the record, I'll put it on the record that I object. Under threat, duress, or coercion, again,
Your objection is noted.
right, and under threat and duress and coercion, I'll be here.
Is there anything else?
I said what I need to say.
Anything else from the people?
No, Your Honor. Thank you.
Bond will continue.
Am I waiting for paperwork or I get it from the front? Am I waiting for paperwork regarding the next?
No, you may leave.
Oh, is it being mailed? Or I'm trying to figure out how to get the paper.
You can check out at the front counter.
Okay, thanks.
Basically, he wants the judge to pause everything and argue whether the court even has the power to hear his case. Folks, that's like showing up to a football game and arguing whether the referee is really allowed to blow the whistle. You're already on the field. It's happening whether you like it or not. The judge, clearly fed up, finally tells him, "Fine, put your nonsense in writing. You're wrong, but at least I'll have proof you're wrong in black and white." That's about as brutal as it gets in a courtroom. Imagine the judge saying, "Go ahead, file your paperwork. It won't matter, because I already own you under the U.S. Constitution and the laws of Michigan." End of discussion. But even after that, the defendant keeps trying to drag it out, asking for delays, objecting under threat, duress, and coercion, talking about trusts, contracts, and clauses. Like he's quoting from a conspiracy website. And the judge, completely done. He cuts through it all and sets the next hearing date. Then, in one of the coldest mic drops I've ever seen, he tells the defendant, "You may leave. No lecture, no patience left. Just, you may leave." That's the courtroom equivalent of being shown the door at a comedy club after bombing your set, and here's the bigger picture. This isn't just one guy acting foolish. This whole sovereign citizen movement is spreading. More and more people think they can wiggle out of consequences by inventing fake legal loopholes. But here's the truth. Judges like Simpson aren't playing games. If you walk in with word salads instead of facts, you're not only wasting everyone's time, you're digging your own grave. So, was Judge Simpson too harsh? Honestly, no. If anything, he was patient compared to what most judges would have. Done. This defendant thought he could twist the system, but all he got was a reality check and a one-way ticket to the next hearing, where things will only get worse if he doesn't wake up. So here's where we step back and really take this in. A grown man walks into court, lies about being sick, smirks at the judge, and spends the entire hearing throwing around legal buzzwords he clearly doesn't understand. And for what? To try and convince himself, and maybe the internet, that the law somehow doesn't apply to him. Judge Simpson handled it exactly the way it needed to be handled: firm, direct, and absolutely unwilling to let the courtroom turn into a stage for conspiracy theater. And let's be real. If more judges shut this nonsense down early, maybe we wouldn't see so many of these sovereign citizens clogging up the courts with word salads and fantasy arguments. Because here's the truth. This movement isn't about freedom or rights or even the Constitution. It's about avoiding responsibility. People buy into this stuff because it promises an easy way out. No accountability, no consequences. Just magic words that supposedly make laws disappear. But life doesn't work like that. And sooner or later, every sovereign citizen finds out the hard way that the system doesn't bend to their beliefs. So, what do you think? Was Judge Simpson fair? Or do you think he went too hard on this guy? Personally, I think the judge did exactly what was needed. Cut through the circus, shut down the games, and remind everyone in that courtroom who's really in charge. Because at the end of the day, the law doesn't care about your theories. It cares about facts, evidence, and accountability. And if you walk into court thinking you're above that, well, you're about to get the same reality. Check, this man just got